Hi, this is Lisa Nichols. I'm a business coach and EFT tapping practitioner, and I have with me today Ryan Apperson, who is an estate planning attorney in Walnut Creek, California. We're going to talk all about estate planning for businesses. So welcome, Ryan. Thank you so much for being here with me today. I'm so excited to have you here. And why don't you introduce yourself?
Well, I'm Ryan Apperson. I'm an estate planning attorney in Walnut Creek, California, focusing in estate planning, trust administration, and probate. But my favorite thing to do is to help, young families who have just bought a house, are having children, starting businesses, making sure that those assets are protected from our probate system here in California.
Got it. And how is business estate planning different from personal estate planning?
Well, in terms of the evaluation of the asset, the way that we evaluate, your worth, the probate code will look at businesses or real estate or other assets exactly the same. And there's a certain threshold you can't cross. And when you do, your estate will be subjected to the probate system in California if you haven't otherwise planned. And that threshold is not very high in California. The probate code sets it at $184,500. So if you're $1 over that, the court will kind of establish its jurisdiction over the transfer of your assets. And the way we avoid court control is by placing those assets in trust. So the planning looks kind of the same no matter what type of asset you have, but businesses can add an extra layer of complexity. Often we will assign the business interest to your trust, whether it's in an LLC or a sole proprietorship, et cetera. But sometimes there's even more planning that has to go into it. So like if you have a business partner, we have to discuss who has the right to, buy out your interest. Is it that business partner, or are you leaving your interest to the surviving spouse that you leave behind, or your children? So a lot of that gets covered in your, articles of incorporation or your bylaws or your operating agreement, but we'll also cover it in your estate plan to make sure that all the bases are covered and everyone knows, who has what responsibility after you've passed.
Yeah, if someone passes and their business share, your partner's business share goes to their spouse, all of a sudden you're in business with someone you may not want to be in business with.
Right. Or if it can be considered separate property, meaning like maybe you were in the business before you got married, it would be some combination of the surviving spouse and the children that would own a portion of that business. So it's not necessarily just surviving spouse that becomes an automatic interest holder in your share of the business.
Oh, yeah. And the more people that get involved, the more complicated it gets.
Well, when you set out to do business with a business partner, you don't really envision going into business with your partner's spouse, and that can cause a whole bunch of problems. So we want to address that whenever we can.
Yeah. Okay. So let's talk about sole proprietors. What are they supposed to do?
Well, sole proprietorships is kind of the default. If you just kind of hang out your shingle and start selling, a product or a service, there's no real separation between you as a person and your business. But even still, you might have accounts that you operate under a business name. Those accounts will be evaluated as part of your business for the purposes of probate. You might have stock of whatever you're selling. You might have, furniture or computers or other assets that are evaluated as part of the business. And we need to make sure we have assigned that interest to your trust, because otherwise the transfer of those assets after you've passed away could cause trouble. And we're trying to stay out of court, and we're trying to be able to transfer those assets to whoever needs to get them once you've passed away without the hassle of getting a court order.
Got it. And so like with this, I think what you said was like the LLCs, the partnerships, the S corps, et cetera, they have articles of incorporation and other documents where like succession planning and all of that should be in those documents, but solopreneurs don't have those kinds of things. So does it just go in their regular estate planning documents?
It does, and so would like an LLC interest, by the way. We would just assign that interest to the trust either way. But let's say you have an account in the name of your business. If your surviving spouse or whomever shows up after you've passed away to try to access that account, the bank won't know who they are. They will not grant them access unless you have some additional planning in place. Now, if you've assigned that asset to a trust and your successor trustee, which may be your spouse, your child, or someone else, shows up with a copy of your trust and a copy of your death certificate, they're going to get access to that asset just like any other asset you've placed in your trust.
Okay, like your home or whatever
Exactly
it is.
Right. Exactly.
Okay. So what are the main points that need to be addressed when you're estate planning?
Well, so when you're doing estate planning kind of in general, we look at a couple of things. What assets are valuable enough to cause probate trouble? We want to stay out of court as much as possible. Who is going to inherit the asset or assets? who is going to manage the estate once you've passed away. And if there are young children as part of your plan, you need to make sure you've named guardians to care and raise them. That may or may not be the same person who manages the money, but it can be. But if you don't name a guardian or a successor trustee for those individuals, ultimately a court has to decide. And the court only knows really what shows up in front of it in form of evidence. So the person who you may not have chosen to be your successor trustee or the guardian for your children may put on the best case, and they may get awarded control of your assets and or guardianship of your children. So it's always better to put your nominees in writing so that we can avoid that conflict or that potential conflict after you've passed.
And I understand that going into probate is very expensive, and it's not necessarily the individual lawyer's fault. It's prescribed, isn't it?
Well, the default, I guess, to be honest, would be everything goes through the courts, and the courts will follow the estate plan that's written for you by the California legislature in the probate code. The distribution of assets is kind of what you'd expect. It's some combination of spouse and or children or next of kin. But when we're talking about businesses, you may have a specific plan about where you want your share in the business to go. You may have a child that you've been grooming to take your place. You may have a business partner who you want to leave that asset to, or you might want the asset to continue to grow and be a family asset, but you want to name someone in particular that can carry on the business and has the legal authority to do so. If you don't do any of that, what's kind of wide open, it goes to the court and it will be distributed in accordance with the probate code's plan eventually, usually about a year after you file the initial case. So it's time consuming and it's expensive and it's completely avoidable.
And by expensive, there are set rates for the attorneys, isn't that right?
So yes, it's not just the attorney either. The fees are set by statute for probate. It's somewhere around 3% of your estate, and that's calculated based on gross value, not equity. So they look at the actual gross value of your assets, and there's a set percentage that will go to any attorney that you've hired as a statutory attorney's fee. The person who hires the attorney, usually the family member who's bringing the case to probate, is entitled to the same fee. So it's actually closer to 6% or more of your estate that will go to someone other than the heirs that you might want the assets to go to. So it's a very expensive proposition. And again, it's completely avoidable.
Mm-hmm. And when it comes to like being in business with family members, like your spouse or your children or your sibling or something like that, are there special things that need to be addressed?
Well, if let's say that you have been working with one of your children and you know that they're the ones who are going to take over your business. Well, if you're going to leave the business to that child, you might want to offset and leave other assets for your other child or children. So that has to be discussed as well. If we're leaving the business entirely to this one person, does someone else get some other type of asset instead? The other thing that I'm really concerned about, and we touched on this earlier, is if you've passed away and there is, let's say, a buy-sell agreement outlined in your documents when you establish the company, and you have someone who has the right to buy your share, how are they going to fund that? And most of the time, we can accomplish that by taking out life insurance policies on the individual that can be used to buy out that person's share. So let's say you even have a business partner. And again, you don't want to go in business with the spouse or the children of that deceased partner. The two business partners take out insurance policies on each other, and that allows the surviving business partner to buy out the family and not have to go into business with people that they didn't plan on going into business with. So your estate planning, lawyer, your financial advisor, your life insurance person are all people that could be part of putting together an advanced plan on what to do with your business interest. Now,
there are lots of templates out on the internet for DIY, and will estate planning attorneys like you review them for anything? Or
so I will certainly review any existing plan that comes through the door and give my thoughts to a client. Attorneys in general are unlikely to amend other attorneys' work, and we're certainly unlikely to amend work that was put together by some sort of software or some sort of bot online. The reason is we've taken all the malpractice liability of any mistake that might have been made previously. So most attorneys will want to redraft documents and put kind of their own stamp on them. That being said, though, if you've put together an existing trust through an online service, that trust may very well still be a valid entity that can still exist. So if you've placed your house in that trust, or you've placed your business interest in that trust, we can still restate it as long as it's a revocable trust and put new modern terms in it. So I certainly will review those plans, and most of the time we end up finding things that need to be done in a different way.
Okay. And well, speaking of, how often should documents be reviewed and updated?
Well, my closing letter to clients usually says, let's check in every 3 to 5 years to see if there's been any life events that may necessitate a change. And those life events are kind of what you'd expect, births, deaths, marriages, divorces, influxes of wealth one way or the other, new acquisition of assets, etc. But ultimately, whenever life changes in that way, you should be revisiting your estate plan with your estate planning attorney.
Yeah, I know. I waited, probably 10 years after my oldest became an adult. And so my trust still had, it was probably more than 10 years. It was like 20 years. So my trust still had guardianship for my adult daughter. So that was way too long. I definitely should have updated it before then. So we've talked about basically about if someone passes away, but estate plans are also good for other instances. Like I was helping a friend who had early stages Alzheimer. And one of the first things I did was jump in and get her to get an estate plan done before she became too far gone, basically, to be considered mentally competent to create an estate plan. So conservatorships or guardianships or anything like that. So what are other things that this helps to address?
So yeah, when we say estate plan, in addition to some combination of a will and a trust, we're also usually talking about powers of attorney for financial transactions and advanced healthcare directives. Those two documents are specifically their purpose is to address incapacity or lack of capacity, or declining capacity. And their purpose is to avoid a different type of court procedure called conservatorships. So if you lose the capacity to execute financial transactions or healthcare decisions, and you have not empowered anyone to make those decisions for you, we have to go to court and get a court order. We have to put on evidence to say who would be best suited. We have to prove that you're incapacitated. So this is another type of court proceeding that we'd like to avoid, and we handle that through those two additional documents: the durable power of attorney for financial transactions and the advanced healthcare directive. They're both very, very important. But especially if you're a business owner, your durable power of attorney for financial transactions will allow someone, the person you've appointed as agent, to carry on your business affairs if necessary. So it's hugely important for business owners to plan in that way.
Awesome. Okay. And you mentioned a will. We mostly talked about a trust, but I believe the will is considered a pour over will. And so why is it important to have both?
So the best way I can explain this is the default is that every adult needs a will, a power of attorney, and a healthcare directive. Once you've acquired a certain level of wealth so that your estate is valuable enough to go through probate, we add a trust most of the time as well. At that time, the will becomes what's called a pour over will, because it's no longer the main testamentary instrument that we use for estate planning. It kind of gathers the non-beneficiary designated assets, like the contents of your house, automobiles, maybe smaller accounts like checking accounts, and it pours them into the trust when you pass away. And and that trust already contains like your business interest, your real property, the more valuable things. And the trust becomes kind of the main instrument that we use for estate planning. The will is still necessary. It will still name guardians for your kids, for example, but it becomes a less important document once you've added a trust to the mix.
Okay. And so last question. How can people get themselves to do this? I know a lot of people wait way too long. They don't think it just is low on their totem pole of priorities, and it's not a comfortable thing to think about. What if something happens to me? What if I get hit by a bus tomorrow, et cetera? People don't want to think about it. So what's a good way to encourage people? I truly encourage people to do it. It's definitely a passion for me. And so how can we get people to actually do it?
Well, I mean, that's my biggest struggle is getting people, this is what I do for a living. I'm trying to talk everyone I can into doing this because I do think it's important. But ultimately, the difference between something happening to you and you having no plan in place and having a plan in place is huge. If you've lost someone who doesn't have a plan, your family is mourning your loss, and then they have to deal with a series of institutions, whether they're banks or insurance companies, et cetera, and a court system as well. And in fact, most of the time they can't do anything until they get into court. And so you've compounded the tragedy of losing someone by making it harder for the next of kin to move the assets around and distribute the assets, et cetera. So instead of being an additional burden after you've passed away, you've turned an estate plan into a gift. And it's really that simple as far as I'm concerned. I think that people don't do this because you're right. No one wants to talk about this. But I think that once you start the process, the client often finds that it's easier than you think it's going to be. My process is usually one meeting. We can meet over Zoom if necessary. We talk about your assets, your heirs, your plan for your heirs, who might manage your estate, who might care for your kids, et cetera. We talk about healthcare directives and end-of-life care decisions. And once that's done, I send you drafts, you review them, you ask questions, you issue revisions, then we meet, sign, and notarize the documents. It's usually that straightforward of a process. A couple of meetings, a couple of uncomfortable conversations, and then you can put it into a drawer and forget about it, and your family will be much better for it.
Absolutely. Well, thank you, Ryan. Is there any last little something here?
Nope. I just
your estate plan done.
Yeah. It's honestly it's not as bad of a conversation as you think, and the overwhelming feeling at the end of the process is relief, knowing that you've taken care of this, and it's less for your family to worry about when you're gone.
Well, and I would say for business owners, we have so much to do on our plates all the time. It's a very stressful, ongoing commitment. And yet, this is one way that we can relieve our own stress around what would happen to our business if something does happen to us. Absolutely. And just know that it's put to bed, so to say, and that there's a plan for it. I think it just is so helpful. And it's just part of normal business planning, in my opinion. So great.
I agree. Treat it like anything else on your to-do list. It feels good when you check those things off.
Yeah, exactly. Well, thanks so much, Ryan. I really appreciate it. Thanks a lot for being here.
Of course.
All right. That's it for today. Bye.